In certain circumstances, following the filing of a Canadian immigration application, the immigration authorities may be close to making a negative decision, refusing the application. But before doing so, they typically will provide you with what's called a procedural fairness letter. This letter allows you an opportunity to respond to the officer's concerns before they make a decision. But how do you respond to a procedural fairness letter? Welcome back. My name is Donovan Francis. I'm a Canadian immigration lawyer at Goose Law Immigration, and we help businesses with their employees' work permit applications and save them from all of the legal hassle. In this video, I want to spend some time talking about the procedural fairness letter, which is a letter issued by the immigration authorities to applicants who have active immigration applications and which have issues that are of concern to the immigration authorities and which potentially may lead to the refusal of those applications. Before making a decision, however, the immigration authorities have an obligation to give applicants an opportunity to respond to whatever concerns the immigration officers have. And this is generally known in law as procedural fairness. Procedural fairness says that you must be allowed an opportunity to understand the case that's being made against you. You must be allowed an opportunity to respond to any concerns or any claims that one has against you. So in the context of Canada's immigration law, if an officer is going to be refusing your application based on certain serious grounds, especially where the officer's decision could have a long-term impact on the applicant, then the immigration authorities have a responsibility to provide the applicant with an opportunity to explain their circumstances and answer any questions that the immigration authorities may have. And so oftentimes, when one has an application in process, such as, say, a spousal sponsorship application, and there are concerns around the genuineness of the marriage or of the relationship where they're unmarried, if they've not been together for a significantly long time, or if the officer has doubts about whether or not the marriage is legitimate and was entered into for genuine reasons, then the officer may have questions, and before making a decision, the officer may likely issue this letter, this procedural fairness letter. In other situations, where there's a risk of misrepresentation, where the applicant has either stated something that has been found to be inaccurate or where the applicant has withheld information that could otherwise have been impactful on the application, then in those kinds of circumstances, because of the risk that comes with a misrepresentation, the immigration authorities would have a responsibility to issue an opportunity to the applicant to respond. And this is issued in the form of a procedural fairness letter. And there may be other circumstances as well, if one has had certain criminal issues in the past or medical issues in the past, those may be situations in which a procedural fairness letter may be issued, or other circumstances, right? So it may vary. So what do you do if and when you're issued a procedural fairness letter? Well, first of all, you have to understand that if an application gets to the point where one of these letters is issued, then it means that there's a very serious concern that the immigration authorities have, and failure to address that concern, especially within the stipulated time frame, because there's usually a deadline associated with these requests. Failure to address that will result in the refusal of the application. And so the procedural fairness request has to be treated with a great degree of urgency and importance. The other thing you need to bear in mind is that your response needs to be robust. You need to be prepared to not just provide answers to the questions being asked, but also to provide supporting documentation to support whatever responses you're providing to the immigration authorities, because that's going to be important. So, for instance, where there are concerns around the genuineness of a marriage, when we're putting these responses together on behalf of clients, we ask the client to go above and beyond in providing documentation that shows, a history of their communications with each other, history of them spending time with each other, photographs, receipts, bank statements, joint bank account statements, joint insurance policies, any kind of documentation that's going to show that they've been together for an extended period of time, and that's going to help to show that their relationship is genuine. We ask that those material be included along with the written legal submissions that will be accompanying the response, right? So that's how you're going to be dealing with a procedural fairness letter, generally and specific to the context of the genuineness of a relationship being questioned in the context of a spousal sponsorship application. In other circumstances, if there's a question around one's medical situation that potentially could lead to them being inadmissible on medical grounds, you want to be sure that you understand the concerns being raised. You want to be sure that you are clear on the reason why the person is being deemed potentially medically inadmissible, and then be prepared to address those concerns. If the concern has to do with a fear by the immigration authorities that the person's illness will pose an excessive demand on Canada's healthcare services, then you must be prepared to show that actually the contrary is true. Maybe the treatment costs for this person's illness are not significant enough to exceed the minimum allowable amount by the Canadian immigration authorities. But whatever the explanation, there needs to be supporting documentation. So maybe something from your current medical practitioner explaining that the treatment really does not cost as much as the minimum allowable amount in Canada's immigration system. And you want to take a similar approach no matter what the nature of the potential issue is, right? You want to be always able to address the concern by raising arguments to counter the concerns raised by the immigration authority. But secondly, you want to also ensure that you have additional supporting documentation to help bolster whatever arguments you'd have been including in your legal submissions. At the end of the day, it is crucially important that if and when a procedural fairness letter has been issued to you, then it is something that has to be treated with the utmost importance and the utmost urgency, because failure to do so will lead to your application being refused and could potentially have even more far-reaching long-term impacts. Okay? I trust you found value from this. As always, remember to like our video so others will see more videos like this. Subscribe to our channel and check us out on go.gooselaw.com. Thanks. See you again.